Most of us take our picture of how people get to be judged as guilty in our society based on what we see in movies and TV shows. And that is in the context of a jury trial. The reality is that the vast, vast, vast majority of people who are found guilty in our American criminal justice system are people who never went to trial because instead they accepted what most of us call a plea bargain, and I'm going to prefer to call a plea negotiation. In fact, although it's going to depend from jurisdiction to jurisdiction, approximately 95% of criminal sentences result from guilty pleas, and only about 5% result from trials. Those guilty pleas can send people into jail, prison, probation, and a range of other sentences. So we really need to pay a whole lot more attention to these plea agreements or plea negotiations than we do. And you'll also see why I spend so much time talking about the prosecutor, because the prosecutor turns out to be a key actor in defining what a plea negotiation is going to look like. So let's start off with a little bit of a definition. A plea agreement or plea negotiation is a guilty plea given by a defendant, represented by his or her counsel or lawyer, to the prosecutor who represents the state, and judges have to accept it to make it legally binding. Very importantly, notice that one of the elements of the definition is not, emphasis on not, bold, underlined, italicized, that a person gets a lesser sentence. Most people tend to think a plea bargain is when a person either gets away with a crime without punishment or gets a much reduced punishment, but that is not necessarily the case at all. It can be that they get away with a reduced punishment. It cannot be that they're not charged with a crime, because by definition, the person is pleading guilty to a criminal charge. So you might want to also be asking yourself, why do I prefer the term plea agreement or plea negotiation to plea bargain? Well, I think the word bargain tends to suggest that somebody is getting a good deal, and we tend to think it's the criminal defendant. Sometimes a criminal defendant does get a good deal through a plea negotiation. However, sometimes the state, representing us, the people, gets a good deal, and sometimes nobody gets a good deal, but nevertheless it's a negotiated settlement to find a solution to a problem. So the bottom line is each side gives up and receives something in return for the agreement, but in most cases the prosecutor has more power to shape what is being given up than the defendant. There are some exceptions though. So for example, in the case of a defendant who has more to give than a prosecutor, you might have a high-level operative in an organized crime group, say a international drug syndicate, who might be able to obtain a minimal sentence and punishment despite really awful crimes, because usually he, sometimes it's a she, can share damning and damaging information about others. So for the high-level operative in, say, this international crime syndicate, the fact that the person can get a lower sentence by naming names is a good deal for them. But what about the opposite situation? Legally speaking, the Supreme Court has said it is perfectly acceptable for a prosecutor to increase the charges, and what some people would argue get engaged in overcharging in order to persuade the defendant into pleading guilty. So a good example of what some people would see as overcharging would be a situation where a person was charged with an attempted murder instead of an assault. And the prosecutor says, I tell you what, I'll offer you a great deal. I will offer you the deal of pleading guilty to an assault rather than to attempted murder. If you're looking at attempted murder, oh, you're going to spend the next couple of decades in prison. If you're looking at assault, you'll probably be out in a few years' time. So many people would much rather take that option than go to a trial. So incentives and disincentives can and do work on both sides of the equation in terms of both defense and prosecution, which helps us understand why people plead guilty rather than go to trial. One thing that we perhaps haven't fully explained or haven't got to in understanding this dynamic is it's not just about the prosecutor and the defendant. It's also about the relationship between and among what some academics refer to as the informal court working group, which is made up of at least the prosecutor and defense attorneys and sometimes the judge. And what we see here is, in practice rather than in theory, a moderation of our formal adversarial justice model, where prosecution and defense are supposed to be fighting against each other no matter what. In the real world of prosecutors needing to process many cases, defense lawyers needing to process many cases, both of them and their offices working and interacting all the time. Maybe they even went to the same law schools or have the same circles of friends in many cases. In those situations, they're going to sit down and talk about it. And they're going to look at what each can give the other to make the system work. So they've both got to process more cases than they have time to do. And so each side is going to look at what's my strongest case. What's my strongest case as a defense lawyer? What's my strongest case as a prosecutor? Those that are my weakest cases might be the cases that are best for me to negotiate with my counterpart. And that's very often how the informal working group works. So in contrast to the generalized public perception of lax justice as being the primary concern with plea bargains, or the public concern with people getting away with crime or getting off easy, arguably the things which should concern us about plea negotiations is not that people are getting away with crimes, they're not, or that there's lax justice, sometimes yes, more often no, but rather that people are legally being encouraged to give up their constitutional rights to things like a jury trial, give up rights to appeal, and so on, in order to plead guilty. Now, to the extent that this makes our system more efficient and it allows guilty people to get punished faster, that's a good thing. But to the extent that we are breeding disrespect or contempt of the law, or stopping innocent people from pleading not guilty in a trial because they're so scared of what happens if the worst possible penalty, if they are charged with the worst possible penalty, that's not good. And more generally, it undermines both the public's understanding of the real way the criminal justice system works and minimizes judges' involvements in the plea system. Although judges have to sign off on a plea negotiation, in practice they tend to be minimally involved. Finally, although this only happens in a small minority of cases, it is not insignificant and not irrelevant that sometimes innocent people will plead guilty to acts they did not commit in order to engage in a favorable plea bargain because they are more scared of the consequences. I'm not suggesting that's the case in most situations. It's not, but it certainly is in a small minority of cases.